Good morning. This is Sumit Pahwa here, your host for the day. So let's start with the topic today. It's a wonderful topic, let me say, the Digital Personal Data Protection Act 2023. It was recently passed by both the houses of parliament and became a law after receiving president assent on 11th of August 2023. So it's one of the first seminars on the topic, I would say, where as we are now reading the law, as everybody is now reading the India's first data protection or data privacy regulation. So it's a landmark legislation, I would say, since it's the first one in India, much awaited for many years. Earlier, it was called a PDP bill, and now it has become a DPDP Act, Digital Personal Data Protection Act of 2023. Now, the DPDP Act aims to protect the privacy of individuals in this digital age. It defines for the first time what is personal data, how can that be used, to identify an individual, which organizations can collect, how they can collect, what is the process, what are the consent, how to obtain consent, etc., etc. So, although the IT Act was there for many years, but today we have experts with us to now brainstorm on this new law and answer your queries and see that how this law will now apply to all of us as organizations, as professionals, and as users. I'm your host Sumit Pahwa. Just a brief introduction about myself. I'm a corporate lawyer and company secretary with 25 years of experience, and I'm a corporate lawyer and a cyber lawyer. And currently, I'm a co-founder and CEO of Complinity Technologies, which is India's leading compliance software, helping companies comply with the laws of the country. Complinity covers over 2,000 laws and a checklist of over 25,000 compliances across all 50 plus industry verticals. And we're adding value to 1,000 plus companies like Panasonic, Max Hospital, Oberoi Hotels, Toyota, Yes Bank, British Council, and many more across 50 plus industry verticals. Joining me is Dr. Mahendra Limaye, our speaker. He is advocate Dr. Mahendra Limaye, a techno-legal expert in cyber security and cyber legal education. Dr. Limaye is a diploma holder in mechanical engineering with masters in law, PG diploma in cyber law and information technology, and also holds a PhD in cyber laws. He is a certified data privacy professional by FDPPI. Dr. Limaye is a guest faculty for cyber laws and cyber security in various educational institutions and government organizations. And he practices cyber litigation as a specialized domain, and also represented adjudicating officers across various states and high courts. And he's also been invited by Niti Aayog to share his views on cyber security. Welcome, Dr. Limaye, to this forum. And pleasure to have you. And you've been there last year in one of our initial webinars on IT Act also when the new rule comes. So welcome again, Dr. Limaye.
Thank you.
Yeah, and also welcoming Mr. Samir Mathur. Mr. Mathur is a seasoned IT professional and has over 3 decades of experience and is currently the managing partner of SM Consulting, which is primarily into cloud advisory services, IT infrastructure, network design, IT audits, cyber security, data privacy, and IT management consulting. Samir is also the president and member of the Governing Council, Delhi NCR chapter of Foundation of Data Privacy Professionals in India. So Samir has been really actively involved on the data privacy side and the IT side and the cyber security side. So I think it's a great mix of a lawyer, Dr. Mahendra Limaye, also a lawyer in me, and an seasoned IT professional, Samir Mathur. Welcome, Samir, to the forum.
Thank you, Sumit.
Yeah. Now, okay, so before we jump into the topic, we have a very small opening poll. Let me just launch the poll. Okay, if you could quickly answer, which role describes you best? So this will, help the speakers identify you. So are you legal or compliance professional, or are you a finance professional, HR professional, IT, or others? Others, of course, could be anybody. But yes, it'll give a flavor. And also, have you read the DPDP Act 2023 or the previous PDP bill? This will also give the speakers the idea of how much depth to go into. So very quickly, if you could answer this. And we have a great attendance, Dr. Limaye and Samir. You can see people have turned out in good numbers, exceeding expectations. So I think we have a great responsibility to conduct a great session today.
Yes.
Yeah. Okay. So while people are anyways filling the poll, or maybe last 10 seconds, if I may say, quickly, if you could answer. Okay, let me end the poll. I think we've got a flavor anyways. So let me end the poll now. So and share the results. So I think 63% are legal compliance, 5% finance, 3% HR, 17% IT, 13% others. So primarily legal and compliance. But yes, we have a little bit of representation from all other verticals as well. And I think it's a 40-60. 40% have read the act, which is really, I'm happily surprised, and it's so nice. And 60% would like to know today. So all right, this is good information for now. So starting with Dr. Limaye, and by the way, audience, just a couple of ground rules. The Q&A box is open. And by the way, we already have the first question even before we started. Okay, so I being the moderator and also quasi-speaker, I'll pick up I'll pick up the questions either in between or towards the end, or a mix of both. It'll be a panel format. There is no presentation. There is no set sort of format, but it'll be open, free-flowing panel. And we'll also take questions. Try to take questions in between. So you keep putting your Q&A in the Q&A box. And we'll start with our conversation now. So Dr. Limaye, first question towards you. You know, the IT Act has been here for the last 20 years or so with a plethora of rules, and especially Section 43A has been dealing with data privacy sort of issue, though in a very small way. But they were information technology, reasonable security practices and procedures, and sensitive personal data or information rules, 2011. So when I'm saying, when 43A and these IT reasonable security practices rules existed for the last 10, 11 years, what was the need of a separate data protection regulation? And how do you compare this new law to the global counterparts?
Yeah. Good morning or good afternoon, everyone. And as Mr. Sumit pointed out, that Information Technology Act was in this particular domain since year 2000. And this security guidelines or reasonable security practices, or Section 43A, came to be enacted in the year 2008. So from 2008, reasonable security practices guidelines were already existing in Information Technology Act. But the need for this DPDP, or Digital Personal Data Protection Act, is now, after Justice Puttaswamy judgment, Supreme Court, or our apex highest court in India, has literally legalized or accepted that right to privacy is each and every citizen's fundamental right. So previously, under Section 43A, there were only responsibility cast on the service providers, or where data was going to be processed on that particular data processors to process that particular data and follow reasonable security practices and guidelines. Here, after accepting this data or data privacy as each and every individual's fundamental right, the ambit of Section 43A stands more widened, and now Section 43A is applicable or literally required for each and every individual for his or her own data protection. And that's why there was a separate need or special need to make one particular enactment which will protect fundamental right of each and every citizen. So when Information Technology Act Section 43A was there, it was seen as a when personal data was breached by only the person who was processing that particular data, or reasonable security practices were not followed by that particular data processor. At that time, it would be applicable. Now, after DPDP, there are enormous changes in that particular, say, background or backdrop in which data required to be protected. And hence, Section 43 of Information Technology Act is now entirely replaced by this particular DPDP Act. So your question was, Section 43A was as much powerful as much DPDP is right now, but with more and widened powers. So that was the need why DPDP was specifically enacted, and now Section 43 stands repealed after enactment of DPDP.
Right, right. Sure. No, Dr. Limaye, I think the whole industry and the citizens have been waiting for a Indian sort of data privacy law. Of course, as one section, it only receives that much focus, but as a separate law and with the kind of penalties being proposed, I'm sure it'll receive a much better sort of focus, being the DPDP Act. Now, Dr. Limaye, again continuing with you. Could you give at a very high level a snapshot of the act, just an overview? What is the heart of the whole act as such?
So, heart of the whole act is basically the preface or the intention with which this particular act was enacted. So, after Justice Puttaswamy judgment, it was thought by each and every industry professional and individual that only right to privacy will be protected under this particular act. But our lawmakers have gone one step ahead, and the preface now reads as an act to provide for processing of digital personal data in a manner that recognizes both the right to privacy of individual, that is their right to protect personal data, and need to process such personal data for lawful purposes. So initially, the basic heart of act is now processing is being legalized by this particular act itself, because everybody's data will be required to be processed is a new need of the industry, and to legalize that particular data processing and simultaneously protect fundamental rights of the citizen. So it is a mix of fundamental right protection as well as protection of corporate right of processing of data. So heart of this particular act, according to me, is the introduction of this particular act. Then there are very unique features. If we compare the similar or parallel laws available in GDPR or other countries, here Indian lawmakers have given very better position to data whose data is being compromised. They are referred as data principal. And if you go to other laws, they are referred to as data subjects. When we speak about subject, it is somewhat inferior complex is there. When it is principal, we are the main person whom or around that particular data principal, entire act will be revolving. And the concept used in India is data fiduciary. So whoever is processing our data or capturing our data will be holding that particular data in a fiduciary capacity. There will be some responsibilities, some duties, some liabilities cast on that particular fiduciary. So this comparison or this use of nomenclature, that is the data principal and data fiduciary, itself suggests the way by which Indian DPDP will be dealt with. So customer or data principal is at the topmost level, and protection of his personal data is the heart or essence of this particular Data Protection Act. So the data principal has been given some rights. So separate chapter is dedicated. Then data fiduciaries have been given certain rights for processing of data. Then consent is one of the most essential feature of this particular act. So broadly, what will happen or what is the essence of this particular act is whether or whichever organization will be collecting anybody's data, that organization will be now required to first give notice to each and every data principal and see the logic or the thinking which has gone into making of this particular act. These notice would be required to given in all Schedule 8 languages. So whatever languages are prescribed under Indian Constitution, data principals will have that particular right to get that particular version in his or her own mother tongue. So everybody, the broad feature is everybody will be understanding what is the essence of that particular notice. And after that particular notice, every data principal will give consent to data fiduciary, and he will be knowing to which data he has given his consent. So he will be provided a list of, say, ticks in that particular notice that we are fetching these your personal or sensitive data. If you agree, then you will have to give this particular consent. So there will not be any previous like agreements, either accept entire thing or you won't get the service. So there are various enormous good features in this particular DPDP. So broadly, it revolves around data principle, his rights. Another thing is his duty is also held responsible. So there are various duties cast on data principle. As a student of law, we always talk about fundamental rights and fundamental duties. Now, Indian Constitution has these fundamental duties. But if duties are not followed, then there are no punishments for non-following of duties. But here in DPDP, if you fail to follow your duty or means data principle fails to follow their duty, then they will be penalized. So this is another unique concept which is added in this particular DPDP. So according to me, sum up, DPDP Act for the benefit of data principles as well as data fiduciary. Data principle, his rights are recognized. I should say her because there was another new approach in this particular act. The act always talks about she. So it has changed the general bias from he to she. So everywhere you will find she, her pronounced in that particular act. So her rights, data principles rights, their responsibilities, their duties, and the scenario under which data can be captured by data fiduciaries and what would be their responsibilities, their role. Broadly, the act revolves around these main things. Other things are procedural part like data protection board, penalties, etc. But mainly it will clarify what are the rights of data principal, what are his duties, and what are the rights of data fiduciary, and in which circumstances they can process the data. This is,
Awesome.
say, Broadway or
Yeah,
high profile overview.
very nicely summed up, I think, as an overview of the act. And also very nice observation, which I also noticed while reading the act, that he has been substituted with she, which is a welcome step, towards removing the gender bias as well. So, but yes, of course, it says she includes he. So, of course, it applies to everyone, not just the women. Okay, on the other note, now, Samir, I think Dr. Limaye has brought out three very, very important terms called data principle, data fiduciary, and consent. I think which is the heart of or nucleus of the whole act. Data principle being people like us, be it employees or customers or vendors or people whose data is at stake. As he said in GDPR, it is called a data subject, but now it is data principle. Data fiduciary, which would mean people who collect that data. It could be companies, etc. And then third is the consent, that okay, what kind of consent is required before the data could be collected. Now, Samir, my question to you is, what is data? We're talking of data principle, data fiduciary, consent to give the data, but what is data? It was defined earlier. It has been defined here in some other terms. So if you could help start with what is data or personal data or data breach, if you could, talk about these concepts, which are very, very important to start with.
Yeah, thank you, Sumit. So the law is very clear on what data is. So data, it says, is a representation of information, of facts, concepts, opinions, or instructions in a manner suitable for communication, and interpretation of which could be done directly or through being processed by either a human being or by automated means, which basically trying to cover that all the processing being done by AI is also covered. So that's data. In normal terms, they are saying that because, as Dr. Limaye mentioned, the heart of the law is privacy of the individual. So the core of the purpose of the law, if you ask, is protecting the privacy of the individual, digital privacy of the individual. And that's why the definition of data then converts to something called PII, the personal identifier information. So in other words, any information out there which can be connected back to me as an individual is data, right? Could be my name, mobile number, PAN card, Aadhaar card, financial information, medical information, sexual orientation, religious beliefs, everything is covered there, right? Of course, you will go into detail on that. So that's it. Data fiduciary was already defined by Dr. Limaye. So your question of data is anything which represents me, by which I can be identified, right?
So that means, Sumit, just to clarify, your means anyone's PAN, Aadhaar, email ID, mobile number, date of birth, all even biometric information, that is also data, medical records, sexual orientation.
Yes.
Now,
Everything.
on a lighter note, we have been hearing from our relatives abroad most of the time that how do you guys ask age everywhere? Be it you when you go to the doctor or when there is any application form, there is age and so many other questions. But they say abroad they never ask age for anything. It is irrelevant. So is your age also again on a lighter note? Will age become sensitive personal data or personal?
See, this law is right now in a very broad and a very general form. Details will be notified through rules as defined by the new board which will be created called DPB, Data Protection Board. So Data Protection Board is shortly to be formed. I am guessing a month or two, and then Data Protection Board will come out with exact rules. But coming back to a question, yes, any collection of any personal information is going to be in a consent form, and the purpose and the duration of the consent has to be defined. And the law clearly says that the consent cannot be by force, and I have a right to withdraw the consent, that I gave you consent, but I want to withdraw because I'm not comfortable. And the consent should be in an unambiguous form. It should not be a technology or such legal parlance which I don't understand. So the consent has to be very, very clear. On the other side, it also says that if I want a service from a vendor X and he has asked for consent and I am not giving my consent, I am refusing to say yes or no, then the processor / fiduciary has a right to assume that the consent is given. So they have also protected the other side. A lot of people refuse to give consent because they are not clear or they are not bothered. So they have given that leeway to the processor and fiduciary that yes, if the subject, the data principal is not saying yes, it is a yes. Unless they say no. Unless they say no, yes is assumed.
Okay. So it's a deemed yes until you say no, because if these services have to go on and all that.
Correct.
Understand. But I was noticing the definition personal data says means any data about an individual who is identifiable by or in relation to such data. Such a small line, but such a wide line, as opposed to the IT reasonable security rules, which said which defined in great detail what is sensitive personal data. But here it looks like although the rules may sort of clarify it more or abridge it more or whatever, but right now it says any data about an individual who is identifiable or by or in relation to such data is a personal data, and that needs to be protected, and that will come under the ambit. So it's a very, very wide, I think, ramification. Samir, again, one more question to you. What is the applicability of the Act? Means to whom is this Act applicable as such?
So the applicability is very simple. It is applicable to any entity or individual who is processing the digital personal data in either digital form or even a non-digital form where the collection of the data was non-digital on a piece of paper or a register, but it was digitized subsequently. So I could be running I could be a reception person sitting in a reception of a company, and I could be collecting the mobile number and the mail ID and some information of the individual who's coming to the building. So that's a register non-digital data, but I'm going to ultimately have it entered in some digital form. So that also comes to is applicable. So it says processing of digital personal data where the personal data is collected digitally, any organization collecting this, or it could be an individual, comes under. So applicability is very, very wide. It doesn't differentiate between any small enterprise, large enterprise, this turnover, society, trust, NGO, school, college. Everybody is covered because, as Dr. Limaye said, the core is the privacy of the individual. I could be a small organization collecting data of 10 people, but I have digitized it. So the core is that protection of the privacy. Sorry, protection. Privacy, protecting the privacy of the individual, which is easier to do in non-digitized form. If I am collecting data of 10 people every day, I can keep it in a register and keep it logged in my office, right? But the moment I put it in Excel and I put it in my laptop, and the laptop is part of an internet, it is bound, it is theoretically possible to be breached. So the size of the organization collecting data, in theory, is immaterial here. In the previous acts, PDP, there was a little gray area on storing data in India and processing data. In the new DPDP Act, which is now passed, the processing of data is allowed outside India also, and so is the storage. You can store data anywhere in the world except a list of negative countries. Let me repeat that. You can store the data anywhere in the world with primary data being in India and an image copy, as it's called, a DR copy, disaster recovery copy of the same anywhere in the world except negative countries. You can even process the data outside, provided I have taken consent that my processing is happening in Europe or Dubai or Singapore or anywhere. Yes, I have a right to process the data of the data principal anywhere in the world except negative countries, provided I have taken consent.
Yeah, so
Well, of course, the consent. Yeah, please.
Although, so I was saying there, I would sort of interject and say that is half story published. Section 16,
Yes.
Section 16 says the central government may, by notification, restrict the transfer of personal data by a data fiduciary for processing to such country or territory outside India as may be so notified. So, right.
Yeah, so like I said, except negative list, anywhere the data can be stored and published.
Right, yeah, but I just
and
hope that
processed.
when the rules come and when the central government gives the notification, if they come back saying no, data has to be localized in India only, then it has to be subject to those rules. But which is yet to be seen. The Act does not clarify on that count right now.
So as far as my understanding is concerned, they will not come out with specific instructions that the data cannot be moved out. They will say that in the previous law, there is a difference between a sensitive critical data and normal PII. See,
Right.
my mobile number and my name and my mail ID is known to hundreds of people.
Right.
So although it is PII, but it is not so critical. Right? It is not so critical, right? So the previous bill said that can be moved. Critical data cannot be moved.
Right.
Now, first of all, they have removed the definition of sensitive critical data. Right. All data is critical now, or right. Not critical, whatever. So from IT point of view, Sumit, there are challenges in storing everything in India.
Right.
From compliance point of view also.
Right.
So that's why they have given the leeway that the master copy, as it is called, primary copy of data in India, a secondary copy somewhere else, anywhere in the world except negative states. Processing will also happen outside because of various technology issues. So right. I don't think they are going to come back with that. Negative list is going to be published it's actually already there. There is already a negative list of where you can store data by any Indian company. That's why all the Googles and the Microsoft and the Amazons, the large data fiduciaries, have opened their own data centers in India. And the other user-based apps like an Uber or which is an international company, have been forced to open offices in India. Right. So that's it.
Yeah. So, Sumitji, to add to applicability of this act, only one short point Samir missed. He has explained it clearly. That is, this act will also apply to processing of data outside India, where goods and services are offered to Indian data principle. So even data is processed outside India, but those goods or services are offered to Indian data principles. This act will apply to those particular processing also.
Sir. That's why I gave the example of Uber.
Yes.
Sir. Uber is not headquartered in India, but they are carrying my personal data. They know I went from X place to Y place. They are carrying my mobile number, and they are probably having a lot of information about me. So although not an Indian company, but they have given that you can store my primary data in India, copy anywhere in the world, and you can process data also. So in one line, processing of data is a very complicated issue, and it's a very costly issue. That's why they have given the option of processing allowed outside India, provided when I downloaded my Uber app, then they would ask for consent, which I would have given. Somewhere they have to write that we can process outside. I have a right to say no. I have a right to withdraw also. Yeah, please, Sumit.
Yeah, on the governance side, I'd like to tell the audience that there is a chat box, there is a Q&A box, but please use the Q&A box only to put in your questions. I will be prioritizing the Q&A questions, in the sequence of which they are presented. Chat will be done later. So please present all your questions in the Q&A box, which is a better way to put questions, and it will be more systematic over there. Okay, and there was a question on whether this session is being recorded, will be shared. Yes, this session is being recorded. It will be put on our YouTube channels. My team, if you could again give links on the chat box of all the social media. Please follow us, follow Complinity on any of the social media or all the social media. You'll be notified, recordings, snippets, everything. A lot of collaterals will be put of this webinar.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
On a lighter note, I am taking a lighter note now. You should have taken explicit consent from all participants that we are going to record this.
Yeah, sure. No, as a data privacy professional, you
would have explained to them that whatever you are discussing here will be put on YouTube.
Yes. No, so here, yes, you're absolutely right. Also, when the session recording started, I think it's a Zoom feature which says your session is being recorded. Give your consent. So I think that.
But then nobody reads the Zoom's terms and conditions, which are few pages long.
Right.
So it was I can come back to use an unambiguous consent.
Or ambiguous consent. Yes. So yes, to the audience, since we are in a data privacy webinar, this session is being recorded. As Samir had mentioned, anybody who does not want this session to be recorded or may leave. Otherwise, it will be deemed to have consented.
Yes, that's right.
And the speakers, Samir and Dr. Limaye, the excerpts of this webinar will be put on our YouTube channels. In case you have any reservations, we'll discuss it offline. Any which way. Right. Okay. Coming back. So it's nice, I think, discussion on data, sensitive data, data principle, data fiduciary, data localization, etc. Now, Dr. Limaye, I think I can't say another heart of the issue, because yes, there are all important issues. But yes, one very, very big chunk of the legislation is data fiduciary and the obligations of data fiduciary under the Act. So if you could give an overview, because data fiduciary being all the companies who are collecting data. So what is it that these companies, because all these people, many of them would be general counsels, company secretaries, or head of HR, IT, finance, etc., CFOs or CEOs. What should they take care of? Like what does a data fiduciary need to take care of under the DPDP Act?
Yeah, so this is very tough ask because first thing which every data collector or data fiduciary will be required to do is to send notices to all the data principals that we are fetching this much data, giving all the details that we are fetching this much data from you, for which they will also have to seek consent for fetching of the data. So first ask for all the companies, and where I think Complinity like companies will be benefited, that every company will be required to first serve notices to existing data principals that we have fetched this much data as of you, as of now, and if you don't consent for utilizing that particular data, kindly explicitly withdraw your consent. Otherwise, it will be presumed to be deemed consent and we will keep collecting that particular data. So, notice will be the heart of each and every data fiduciary right now. One first small correction is data fiduciary and significant data fiduciary. Not much difference, only as Mr. Samir mentioned, there will be some threshold limit. That is the only difference. But every data collector, every even a small shop which is utilizing digitalized mechanism, like all pharmacy stores, now they have gone online. They are collecting information from the, or they are taking down prescriptions in electronic format, digital format, putting some name of medicine, referral doctor, etc. All these small utility centers to the big corporate social media sites, wherever data is digitally captured, will be termed as data fiduciary. So any and everybody on the now this particular business platform will be termed as data fiduciary, and
Dr.
they will
Limaye,
be,
maybe you can take a minute to explain the difference between a fiduciary and a processor also.
yeah.
Data fiduciary and data processor.
Yeah, so very significant. That is not small. That is very huge difference or in data fiduciary and data processor. Data processor is the organization which is simply processing data. Means I, as a big organization, have subletted the task of processing or say segregation of data, storing of data to some other organization. So that other organization is getting data from me. They are not directly connected with the data principals, but they will be termed as data processors. So they will be processing data according to instructions given to them by data fiduciary. So individually, they will not be liable for data principal. But as a data fiduciary, where I am collecting data, I am processing data, I am making some opinions based on that particular data, I will be termed as data fiduciary, and maximum responsibilities will be on this particular concept or term, that is data fiduciary. Data processor will have some sort of what we can say as intermediary guidelines, some leeway, some protection from the law, but data fiduciary can't escape the law. It will be the job of data fiduciary to send notices, to seek consent, and main thing which corporates must understand from day one is onus of proof will be on the corporates that they have obtained the consent, they have sent the notice. So this will be very huge ask, because if any dispute arises between data principal and data fiduciary, law has made it explicitly clear that the onus lies on data fiduciary to prove that he has obtained a consent, he has sent a notice, what information he has gathered. So, in a way, after this particular enactment of Act, data fiduciaries' compliance part will be immense. They will have to keep register for each and every consent obtained from them, and Act goes one step further, that these consents will be periodically renewed. That will be another huge ask, that renewal of those particular consent, noting it down, recording somewhere. So data fiduciary will have to do their homework well and adopt to the provisions of DPDP, and the legal team of any data fiduciary will be now required to work 24/7, because in-house they will have to put grievance mechanism. Prior going to DPO, that is Data Protection Board, there will be one, say, agency or one officer, which may be termed as grievance officer or data protection officer, who will be the main point of contact between data principal and data fiduciary. So every company will be again required to put up one DPO, that is data protection officer, who will be in charge of protection of this particular officer data, as well as compliance of all the data related queries. So data fiduciaries will be required to start their homework right from day one. That was from 11th August when Act was enacted, and most of the, hopefully, data fiduciaries have started this particular activity, because since Act is applicable, the day Data Protection Board starts its functioning, there may be thousands of complaints waiting for Data Protection Board for non-sending of notices, breach of data, etc., etc. So all the companies which will be data fiduciaries in a way or other, they will be required to take all the precautionary measures and all the compliance measures which are put up or set up in DPDP. So this should be the approach of data fiduciaries to this particular DPDP Act.
Right, right. So to sum up, Dr. Limaye, what you said is, one is the notice to be given by the data fiduciary to the data principal, that what kind of personal data I am seeking to collect, what is the purpose of this data, how you can exercise your rights for grievance mechanism, etc., etc. So that notice will become very, very important. Right. And second is the consent itself, that to obtain that consent for a lawful purpose, basically. For example, the practical implication would be like, just to start with an employee only, an organization hires an employee and collect the entire detailed candidate information form and all the mark sheets and all the sort of family members and mobile numbers and bank account numbers and everything, including biometric and medical records and everything. So I think that data, what Samir was explaining, that if it is kept only in a physical paper, it is outside the purview of the Act. But if it is even PDF, even if it is scanned and put up on the server, or if it is digitized on a HRMS software, or in whichever other format, it will come under the purview. And all the organizations, to start with, must ensure that either you already have a consent, or now you go back and ask your employees for the consent, that okay, I have this information about you for this lawful purpose, and please provide your consent. So this will become a very gigantic exercise. But although I also see that, just like in software downloads, we have noticed that when you're downloading an Adobe, or you're sort of signing up for any SaaS software, there's a small checkbox and there's a small I agree to the privacy policy and the terms and conditions. And 99.9%, I think, including us also, would hardly sort of open those boxes and read the long terms and conditions. We would simply just check in the box and then proceed. So will that, the question to anyone, will that also amount to a valid consent under the DPDP Act?
Yes, of course, it's a valid consent, Sumit. But if I want to be projected as a 100% ethical organization, I will have that 5 pages of consent, legal consent, but I will put the key points in a highlight as a summary at the top, that we are asking your consent, and we will use your data for marketing.
Right.
Which means you agree to receive marketing mailers from us. We will not sell the data to any third party. We might use it to enhance customer experience.
Right.
On our website. So I am visiting the website, and website is asking for consent. It says accept all cookies.
Yeah.
And there is an option of modify cookies.
Yeah.
If I say accept all cookies, I am giving them explicit consent for everything under the sun.
Right.
Right. But if I'm saying modify, I want to get connected to your website, take relevant data, use the data, get information, and then come out of it. But I don't want to be bombarded with marketing emailers for the rest of my life.
Right.
But third one is that if I say reject cookies, then if I say reject cookies, then the website owner has an option of not letting me go further on the website, because
Right.
they are saying we have cookies enabled, and once you have cookies enabled, then the website can track me.
Right.
So they're indirectly saying that we are going to track you if you use our website. And
Right.
by
Right.
saying yes, we are giving them, without reading the whole 4 pages, we are giving them consent. We are agreeing to being tracked.
Yeah. Yeah.
And of course, being bombarded by marketing material. So yes, we have to take care of all this.
It's a very double-edged sword, I will say. Very interesting point, Samir. You said cookies. Again, this is one of the thing. It comes as a very ugly pop-up, which covers 30% of the website from bottom, and we would just accept all in a fraction of a second because we want to go to the content that we have been searching for. And who has the time to sort of with these so small attention spans and bandwidth available? Who has the time to read the cookie policy and see what is being collected, how it is being used? So again, while the data fiduciaries may put up all the legal forms and the check boxes to collect, but it's also on the data principal to be very aware and conscious, and maybe spend that time that what kind of consent I'm giving to the data fiduciary. For example, a very interesting illustration has been given in the Act itself, saying a telemedicine app which you are downloading, and where you can consult a doctor, and it is asking for a permission to access your contact list. Now, saying that this is not okay, because why should a normal consultation with a doctor app should take charge of all your contact list for their own sort of maybe marketing purposes or illicit purposes? So if they do it as a data fiduciary, it will be against the spirit of the letter in the spirit of Act, because even if you give consent as a data principle, but the purpose for which they are asking may not be a sort of a lawful purpose or the most ethical purpose, and therefore those kind of data fiduciaries may be booked under the Act with penalties. That why are you asking for unnecessary information which is not required for provision of goods and services or the transaction? Is that right? Is that the right interpretation, Dr. Limaye or Sumit?
Correct.
Yes, it is right. See, you have to understand from government point of view that explaining what we are discussing right now, there are about 190 participants and 200 people discussing something which is a concept, and it is difficult for us to understand, implement, right? I have been in IT for last 34 years. In the last 4 years, since we have gone deeper into this, into understanding this law, since the first draft of PDPP came, I never used to read the policies, but now it has become a passion, so I've started reading policies. But I can assure you 99%, 95% of IT professionals who understand this, and legal professionals with whom this data is connected, they also don't read. So it's a change. Now this is for us. Now, if this law talks of every individual, even a child or a minor. Imagine 140 crore people. How will you make them understand the meaning of privacy? So, from a
Yeah.
government point of view, it's a very, very big challenge.
Yeah.
Not half, 99% people do not understand the term called harm audit, which means that what will my breach of data, what harm will it bring to me? Why is the government spending so much time? Why is Complinity spending so much time in explaining to me that privacy is important? Why is it important? What harm can it do to me? My number is known to everybody, right from my maid to my neighbor to my friend. Everybody knows my number. Hundreds and thousands of people know my mail ID. My Aadhaar is being distributed lock, stock, and barrel. Here, there, photocopies being distributed to all banks. This, LIC, this, that. Where is the loss of privacy? What will it do for me? And that's the biggest challenge for people to understand, that privacy is a very tricky subject. I could go to a mall and he can ask me, please give me your number, we will send you discount coupon. I'll say, no, you will misuse it. Next day, I am in a different mood. I go to the same shop and I give my number.
Yeah.
So this is a very different concept to understand. And that's why we urge all our clients to understand that this is a change management issue. It will take years for people to understand.
Yeah, absolutely. Mobile number is the most abused any which ways. You go to a restaurant and you are in a 10-minute waiting queue. The girl standing there will ask your mobile numbers on the pretext that she will call you when the table is ready. You go to a grocery shop and they will ask your number because they want to feed into their system, not because of anything else, but so that they can put you on their SMS spam list, so that you start receiving those messages which you can't even block. So I think it's a very the pesky calls and the pesky SMS messages, it's a menace. Despite all the D&D regulations by TRI and all those things, this just doesn't stop. Anyways, again, what will happen to the cold callers and the telemarketers and the databases? I'll tell you, or again on a lighter note, I'll love to share these incidents with the audience. One person called me, from one of the edtech companies. Again, I will not name because of privacy issues, but a very large edtech company, and he said, "Are you the father of so and so name?" He took some name. I said, "No, I'm not the father of so and so name." He said, "No, but as per our records, you are the father of, for example, let's take a name, say Brinda Arora." So I said, "No, I'm not an Arora. I don't have a daughter called Brinda Arora." So he said, "But sir, as per our database, this is it. How can you refuse? This is a OTP validated databases that we have got. I have to sell you a package for the edtech." It was almost a altercation with him. I said, "Boss, the number is mine. I don't know who validated the OTP, but I am not the father of so and so." So I mean, मैंने कहा घर पे लड़ाई कराओगे आप, मतलब this kind of. So anyway, that's a lighter note on data and databases and telemarketing. But coming back to Samir, since Dr. Limaye talked about data protection officer, so first question is, do all organizations now, if data fiduciary is any organization who collects data, which means even if talking of companies, all the 13 lakh companies, active companies in India, okay, I'm not even talking about the proprietorships and the partnerships or the NGOs, although they are also applicable. But even if talking of companies, organized form of business, everybody, even if they are employing 5 people or 50 people or 5,000 people, they're all data fiduciaries. Now, are we saying all such companies have to now appoint a data protection officer, and yes or no? And then in either case, who can be a DPO? Is it an IT guy or a legal guy? What are his roles and responsibilities and stuff on the DPO, if you could explain?
The concept of DPO is very clear, Sumit, that there has to be an independent head, functional head, who is responsible for the privacy of all personal data being carried by an organization. So if you are a 5 people company, so you're carrying personal data of 5 employees, and you might be dealing with customers and vendors and so many other people. You're also carrying personal data of those 25 vendors. So personal data of 25 vendors plus 5 employees of the company, you have to protect the data. Now, if you have to designate one person as a DPO. Ideally, the DPO in a large organization, smaller companies will not have a board. But the previous version of the bill said that the DPO has to report to the board and make it a mandatory compliance issue. At the end of the year, she has to define the number of breaches that happened and what action were taken. Whether you are 5 company or 50,000 people, you have to have a DPO. But doesn't mean that it increases the compliance cost of all the entities. Of course, large entities will have to have a DPO because the regulatory framework will ask them to do it. But coming to smaller organizations, of course, they will probably appoint or give extra responsibilities to one person to act as a DPO, right? Or maybe they will call Dr. Limaye to act as a DPO, or they will call us to act as a consultant DPO. Smaller organization, right? Those things will happen.
Oh, even consultant DPOs can be. I mean, they may not.
See, the law will not mention. Law will not mention that. I mean, you can have a consultant, tax consultant. You can have a investment consultant. You can have a property consultant. Why not a DPO consultant?
New line of sort of consulting I'm seeing emerging as a data privacy professional or a data privacy consultant, which can sort of not only advise you, audit you, also act like a DPO and all that. Amazing.
So we do this function, and the amount of discrepancies we have found in large organizations are really alarming. Alarming means with a capital A, alarming. People have no inkling of what privacy is all about. And that's why, like I said, the base is that people don't understand the meaning of privacy and what harm will it bring to me. So the loss of awareness, the loss of my reputation, the loss of goodwill, those are the losses you will incur if your privacy gets breached. Not many people understand that, right? Unless you are a celebrity, we are not bothered so much about loss of reputation. We don't understand the concept of reputation. So we have in online, we have a business of ORM, online reputation management, which means my online reputation has got breached. So I need to employ an agency to manage my online reputation, which is a business in itself. But we will not go there. So coming back to your question of DPO, yes, in theory, everybody needs to appoint one DPO. Larger organization will have to have an independent data protection office. Large organization will not like to appoint the IT head as the DPO, because the DPO is supposed to audit the IT only. See, the data privacy is all about protection of data, and protection of data by default is a function of the CISO, Chief Information Security Officer, or which includes the function of CDO, the Chief Digital Officer, CIO, the Chief Information Officer, or Chief Technology Officers. Though these people, whether individuals or being the function being carried out by one person, is supposed to protect the data. Now, if he were to become a DPO, then whom does he audit? He cannot audit himself. There is a clash of interest. That's why the understanding is also, this is not mentioned in the law. This is my understanding, that they will want an individual person with knowledge of law, basic knowledge of cybersecurity and IT to become the DPO. Report to the board, present a monthly or a quarterly report to the board that these are the breaches I have found, and then file it as a mandatory compliance. I expect, you are recording this, I should not say, but I'm anyway going to say it. I expect this to become part of the Company Act very soon. Mandatory कर देंगे इसको ये लोग, करना ही पड़ेगा. If you allow me, I'll give you one example. A very large hospital, obviously I will not name, we were doing their audit. And as part of the audit, we went to the website and we were auditing the website in terms of, like we were discussing about VAPT. VAPT we started with. When we went into detail, we had to stop, because all the hospitals are obviously putting details of their prominent doctors on the website, right? If I want to visit a cancer specialist, heart specialist, I'll go to the website of the hospital and see who are there. Now, so in terms of putting the profile of the doctors, they had taken photos of the CV of the doctor and uploaded it. Now the CV of the doctor had the residence address, the qualification, the residence telephone number, everything is uploaded on the website. Imagine a large hospital, actually number one in their field, at least in North India. This is the level of unawareness. I'm not blaming anybody for this level of unawareness in the market. Right?
I think data has been a very abused commodity as far as India is concerned. People have not been really serious about it at all. I think one change, what was my first question to Dr. Limaye initially, but one change this law will bring positively is the sensitization of people towards data, whether it's a data principle in giving the consent, giving out the consent. Now that he knows that he has an option to consent, yes or no, I think we all should be very, very conscious about giving our consent out. And on the data fiduciary of what to collect, why to collect, when to collect, and those under the carpet kind of data collection and data usage should stop. Given the extremely high penalties, that brings to the penalties. In the schedule, for example, Dr. Limaye, I was noticing the penalties are amazing. I mean, every new law that is coming, that is only increasing the penalties. With you and I being legal practitioners for 25 years, we have seen laws with 100 rupee penalty, which still exists, some of them till date, 100 rupees or 1 year imprisonment, with, or both. But now this says may extend to 250 crore rupees, 200 crore rupees, 200 crore rupees, 150 crore rupees, 50 crore rupees. This is really, I think, one of the, I mean, I'd seen competition law prescribing penalties as a percentage of the overall impact. Then even FEMA sometimes in some provisions, but this has laid down 50 crore to 250 crore in majority of the cases. So what is your take, Dr. Limaye? How do you think Indian MSME sector, which is also obligated now to follow this, smaller organizations, how will these penalties be sustainable for these kind of companies? Even large companies, 250 crore is not a small amount as such.
No. What is the difference? Your previous question was 43A and 43 DPDP. Now in 43A, data principal used to get compensated for his or her own personal data breach. And here, these particular penalties are going to government exchequer. Data principal is not going to be benefited. That is the biggest difference between 43A and DPDP. Now, according to penalty, previous act talked about some percentages, that 2.5% or 5% of turnover, 10% of turnover, etc. But looking to the number of data principals residing in India and the volume, means government has already conducted harm analysis of the data principals in India, and then they have come to these particular figures of 250 crore or 150 crore or 100 crore. And mind you, there is small penalty of 10,000 rupees on data principal for not following duties that I previously addressed. That non-following of duty has become a crime now or will be penalized for 10,000 rupees. Just imagine a case, any social media company having big legal team at its discretion, penalizing each and every data principal for 10,000 rupees each. What will be amount that particular company is going to amass out of such sort of non-cooperative attitudes or non-following of the duties of data principal? But yes, provisions of 250 crore, 100 crore, 150 crore are really amazing. But looking at the size of breach which may happen and the loss or harm which may happen to data principal's data, it seems to be reasonably fair penalties. It's not that we have seen a lot of cases of, say, you referred Competition Commission. Bigger giants are fighting for 250 crore penalties, 100 crore penalties coming to settlement. Now those penalties are prescribed by Competition Commission only. And look at the size of penalties which are being submitted to respective governments as a compromise settlement by big media giants. That is Facebook has made compromise penalties of more than what we can have 250 crores in India. So looking at the size, significant data fiduciaries, this amount seems to be fair enough. But a question you raised regarding to MSME, yes, MSME, it could be too harsh because MSME is, by that particular definition, is not the entity having more than 100 crore or 500 crore of the say size of that particular organization, and them facing say penalty or legal liability of say even 10 crore, 15 crore may entirely crumple that particular MSME. But we must understand this is the highest limit, 250 crore. It is not that it will be a rule that everybody will be penalized with 250 crore. It may depend upon the quantum of damages which have been inflicted on data principal. So I am satisfied with these penalties, and being a legal professional, if I get a client for fighting for 250 crore, I'll be really happy, more than happy.
Yeah. Even if you are paid 1% of that, that will justify
more than happy.
All right. And so I think as a last question, before we move on to the audience questions, Dr. Limaye, since you mentioned 10,000 rupee penalty for data principals in case they don't follow the duties. So I think this is something that applies to all of us as individuals, as data principals. So if you could articulate what are the duties of data principals which we need to follow, and if we do not follow, 10,000 rupee penalty can be inflicted upon all of us as well as data principals. So over to you, Dr.
Yeah, so the section prescribes what is the duties. They should not give any fraudulent information, or they should not cheat while giving the information. That is only broadly mentioned. So whatever information or whatever consent they are giving, the information provided through that particular consent or through that particular acceptance of notice should be correct information, fair information, and there should not be any fraudulent angle to providing that particular information. So if you provide your information legally correct, then data principal will not subject to this sort of punishment. But deliberately, if you are misleading someone by opening, say, false social media accounts or giving false telephone numbers to harass someone, then these penalties will be attracted towards those data principal. So basically, if data principal remain, say, providing genuine information, and which I believe Indian data principles are fair enough for providing information in a reasonable, correct manner. So I don't think Indian data principle will have to suffer. But as a legal person, I certainly have some, say, queries or some questions in my mind, that can duties be taxed? If non-breach of duty, if our constitution doesn't penalize for non-breaching of fundamental duties cast on the citizen, why these duties which are under DPDP should be penalized? So there is some sort of legal debate which I have in my mind. But yes, I presume that the penalties prescribed are reasonable enough, because due to which, again, significant data fiduciaries can be put at some risk or at some damage, and that's why this 10,000 is fair enough. How much it will be applicable or it will be enforced, let's see, because unless DPB comes in a reality, and what Samir addressed, that if he presumes that it will be, or what we are waiting at, it will come shortly, if it happens soon, then there will be reasonable good framework for DPB, Data Protection Board in India. So I think duties are fair enough, and data principal, if they provide true and sincere information, nothing to worry about.
Yeah, absolutely. And I was reading section 15 of the Act saying duties of data principal. So it just to read a couple of important words, it says to ensure not to impersonate another person while providing her personal data for a specified purpose. So of course that being an imposter or impersonating or fake accounts, in case those accounts in future are linked with certain illegal activity or any other thing, that impersonation may sort of cost. Similarly, not to suppress any material information while providing our personal data, like any, or not to provide a false information, as Dr. Limaye also said, proof of identity, proof of address, etc. And one important point is to ensure not to register a false or a frivolous grievance or a complaint with a data fiduciary or the data protection board. So in case there is a frivolous grievance reported by a data principal, there also you may be penalized. Okay, so that's on the rights of the data, rights and duties of data fiduciaries, duties of the data principals, data, sensitive personal data, data protection board. That by the way, the law envisages the establishment of a data protection board, which board is not set up right now. But what we understand is it should be very quickly set up in the next few months, maybe 2 months, 3 months, time will tell. And then when the data protection board comes, will then probably they frame the rules, because this requires a lot of now rules to be framed under so many sections to give the practical governance and application to that. And all the complaints or grievances under the law, I think, will first go to the data protection officer, and then the complaints will go to the data protection board, right, Dr. Limaye?
First, it has to be settled by DPO or grievance officer, whatever is available with that particular company. Right. And if aggrieved by that particular decision, then it can go to DPB, means Data Protection Board. And after DPB, it will go to TDSAT. So mechanism is prescribed, but unless DPB is there, don't talk about what are the higher appellate authorities, but those are already prescribed.
Yeah. So while DPB, Data Protection Board, is expected to come soon, and they'll also finalize the rules, etc. The TDSAT has always been existing for TRI disputes, even for the IT Act Appellate Tribunal. TD Telecom Dispute Appellate Tribunal has always been there. So same is the appellate body here. And Dr. Limaye, as we were discussing, the appeals from TDSAT will straight away go to the Supreme Court, right?
Yeah, as per TRAI it goes to, but in IT Act it goes to High Court.
Right. But here they say the appeals of TDSAT will be as per the TRAI Act.
So then it will go to Supreme Court because TRAI directly goes to Supreme Court.
Right. So I think we see a whole lot of new legislation coming up, opening up new opportunities for practicing professionals also to sort of not only do awareness sessions and investigations on data privacy or advisory consulting opinion, and not just practicing professionals, I would say even the in-house professionals to advise their managements on their privacy issues and the consent and the notices, and in case any complaint, and to also act like data privacy officers or grievance officers, and in case any disputes were to arise, to also represent before the Data Protection Board or the TDSAT or the Supreme Court. So I think a whole new bunch of sort of laws and governance and jurisprudence will emerge out of this law, and it's going to be very
Sumit, just I want to interrupt for a moment.
Yeah.
There are additional two emerging opportunities for the audience who are here. One is data protection impact assessment, what Samir has previously mentioned, that every organization will be required to carry out data protection impact assessment. That will be opening enormous opportunities to take guys carry out data audit. And another, which is very what each and every participant should focus on, is consent manager. That is totally emerging new concept in our DPDP, that the consent manager can be able to garner the consent of n number of data principals, and he will have that collective bargaining power of this many data principals. So that is totally new concept, that is consent manager and data protection impact assessment. Apart from DPO, we have two new concepts in our Indian Data Protection Act, where consent manager is for the first time discussed, who will collectively represent the data principals to the data protection board or to that particular committee. Like many times we see data breach happens with the big companies and individual cannot fight. In Consumer Protection Act, we have that particular provision now, that is class representation. Same concept is now modified into DPDP, and consent manager is the new consent or new terminology which will be in process future. So those who are in this particular seminar can also look for this particular two additional opportunity. DPO is already highlighted, data protection impact assessment and consent manager. So emerging or various opportunities will emerge for legal and technology professionals out of this particular DPDP. That was only what I wanted to add.
very nicely put.
I also want to add one very important point from data, the rights of the data principal, that we have a right to correction, completion, updation and deletion of her personal data by DF, which means that I order a pizza from Zomato and I give them a consent and I give them a very clear purpose, which is delivery of food at my home, and I give them 1 hour, and I have a right to go after that to Zomato, that I buy pizza only once in a year. I have given you consent for delivery of pizza, which has come. Very good. Thank you. Now delete my data. Yeah. And the next time I want to order pizza, I will again create a user and again give you consent. So the purpose and duration is there.
Right. No, very nicely. This is also a very, very important point, Samir. I agree. Right to be forgotten, as has been sort of targeted. That
no, Sumit. Right to forgotten is not there. Right to delete is there. Forgotten was there in the previous version. GDPR has the word forgotten. In our DPDP, the word forgotten has been
erasure.
It has been said right to deletion. Deletion and forgotten means deletion is a temporary activity and forgotten is a lifelong activity.
Mm-hmm.
So forgotten word has been removed from this one.
Mm-hmm.
So I saw some HR professionals also here. So they need to understand that I come out with a new JD for a new vacancy, and I get some 100 CVs, out of which I shortlist 20 and I interview 20 and hire one person. Now the rest 99 have a right to come back to me and say delete my data. I gave interview, you did not. I gave you consent only for being interviewed, and if selected, take me on board. But if not selected, I have a right for data to be deleted.
Hmm.
So all these changes will happen. Now, this could happen with vendor. You have a lot of data of vendors whom you are not doing business with. They have a right to delete my data. I don't want my data. Similarly, employees who have left the organization. So unless it's an income tax issue or it's a full final payment issue, they have a right. They can come back to you. So if I'm going to keep my data of employee who left 1 year, I better have a very good reason. That why are you keeping my data? If
Yeah.
I did full and final settlement, why data is still in use? So all these are very important issue from compliance/HR/finance point of view.
Right,
Yes.
right. No, it's quite multidimensional to that extent. And like, in Canada, I had heard of a law called Can Spam Act, for anti-spamming. You can't spam, you can't just pick up email databases and start emailing. Wherein in India, of course, the mobile numbers and email IDs have been quite abused for spamming by whoever concerned. So will this spamming also become such a big crime? Like if for example, Samir, one organization gets hold of say 1 lakh email ID database, and there are certain organizations who sell databases, right, for telecalling, for emailing, etc., for marketing purposes. So are we saying that this unsolicited calling or unsolicited emailing, which is so rampant today, will this become a big crime, attracting big penalties under this law, Samir?
So it's a gray area. Yes, as of date also, it is not legal so I work with one particular bank. If other bank takes my data because the employee of bank X left and joined employee bank B and carries data, so it's already an illegal act, and that data gets further sold to BPOs and KPOs and call centers. It's already an illegal act, but it is on lawyers like you and Dr. Limaye to take it forward that yes, it's illegal. I don't want to be getting mails all my life just because I registered on one Uber or something for one activity. They take my mail ID, and all my life I will get mail. Even if I put it on spam mail, even if I say unsubscribe, they don't unsubscribe you. So it's a very, like I said, it's a change management issue.
Yeah.
Compared to your question, yes, it is already illegal to spam somebody.
Already illegal, but I think if this comes under through the rules also, if it is more explicitly covered, I think the sensitization, awareness, and compliance will be much, much better. For example, India is overly legislated, but less implemented, I would say. But I think with special legislations like these, will only sort of promote compliance. Anyways, since we are talking of compliance and to give a little bit voice to the speakers, so Samir and Dr. Limaye will get ready for a rapid fire Q&A. But before that, so you can have a glass of water before I fire questions which the audience has fired on us. I'll request my team to play a 1-minute video on Complinity, which is India's leading compliance software. Since we are talking law and since we are talking compliance, and it's a very important piece. So a 1-minute video on Complinity, how Complinity helps comply with the laws of the country, including the DPDP Act, and then we'll go to the rapid fire questions. Over to my team.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management, request a demo at complinity.com.
All right, that was about Complinity. As I said, we covered 2,000 plus laws and 25,000 plus compliances now across all these laws and across 50 plus industry verticals, and are adding value to great companies like Panasonic, Max Hospital, LG, Amaron's Battery, Oberoi 5-Star Properties, Artemis Hospital, Yes Bank, and many, many more. Okay, so there's a small closing poll just to know. Anyone who would like to have a demo of Complinity compliance software for your organization, may please register your interest. so that my team can reach out to you offline after this webinar. The Complinity, as I said, is best suited for either MNC companies or listed companies or public sector undertakings or any company, be it manufacturing or services, which is more than 100 crore top line, because there we feel it's enough complexity for you to be, doing a compliance software. All right. So while people are filling up this closing poll, we will start with the Q&A. So Samir and Dr. Limaye, I'll do a rapid fire. I'll ask the questions. Anyone can pick up any question. I won't sort of a few questions which are low hanging fruits. Maybe I'll only quickly answer. But then, in the interest of time, we're already overshooting the time, and there are a lot of questions I see. So I'll be very, very quick and request you to be very brief and very quick as well. Okay. So Mayank says, what was Disha bill?
Related to hospital management. That's all. It
Okay.
didn't see a light of day.
Okay. So Siddharth says Section 7(3) of the Act states that data principals should have the option to access the privacy consent in 22 local languages. So how will that?
So that I have prescribed that all scheduled languages it need to give notice. So company will keep a copy in all the languages, and if asked for, they can supply that particular copy. That's all.
If the data principles are primarily English, then we don't need 22 languages, right? Means the data principle has to be in that language also, no?
Yeah.
Understand. Rashmi says, do we need to take approval from the individuals for using their PAN card, Aadhaar card, passport when required for official purposes?
All personal identifiers, what Mr. Samir has already described.
Right. So all this is there. Siddharth, okay, this is done. Next is there any format for taking employee consent under the DPDP Act? Somnath asks.
It is the role of Complinity and lawyers like us to draft the same now.
Right. No format, but unless it is prescribed in the rules, or else professionals will have to sort of frame certain formats. When are the rules expected to be notified? It's anybody's guess, but yes, I think after the data protection board is sort of formed, we probably can expect. But I think in the next 3 to 6 months, we can see a lot of action, and especially in the next 1 year, a lot of action to sort of happen in the DPDP Act, right?
Yeah.
Divya Pahwa, so okay, I'm also Sumit Pahwa. Hi Divya. So I'll answer your question. Will this act cover on digital data, or any non-digital form will also be covered? So I think Section 3 has very clearly specified digital data is covered, because the name of the law itself is Digital Personal Data Protection Act, DPDP. However, if a non-digital data is converted into digital, either through databases or PDFs or whatever, stored in a digital format, that will come under the coverage, right? Now, Mr. Parandhaman asks, please clarify right to privacy. What does this? Does it mean can I decline even if service provider needs my personal data, or right to consent? Does it mean I can provide the personal information, but I don't want my service provider to share or validate my personal information with government, etc.? Yes. Anyone would like to answer?
Yeah, so right to consent will be there. Again, it will come with some riders. If you provide consent to say 70%, 80% of that, then be offered to you. So companies will also change their strategies accordingly. Whatever is required to them, if that is provided in consent, company will provide 100% service. Or what happens with typical scenario? If you want to disable any feature of any app, they will say by disabling this feature, the app will not work to the extent of 100%. Then they discourage you. So same thing may happen. So consent, anyway, it will have to be what is required for that particular organization. So you have to be clever enough to accept that particular consent clause henceforth.
Regarding sharing with government, obviously nobody will share with government unless this is part of the regulatory. For example, if I need my Aadhaar to be confirmed, right Aadhaar number, so I have to go to the Aadhaar site and get an OTP and confirmation. So this question of sharing data with government will only happen if it is required, right? Unless it's an activity where there is malified intent, which we all understand, right?
Yeah, I'd like to add here that giving consent or not giving consent is entirely your prerogative as a data principal. Providing service or not providing service is the data fiduciary's prerogative as a data fiduciary, right? So if you do not give data, he may choose not to give you service or give you partial service, and that's his right to give or not to give if you're not giving that data. However, if it is something that you really need the service, just like an Uber, for example, you cannot live without that service, and you do not want to give that data, and you have some valid logical reasons Why not to give that data, and why should the fiduciary not ask for that data? There comes the role of Dr. Limaye and myself. You approach the professionals, then those things can be sort of challenged as a grievance to the DPO or in higher forums. Okay, how is the digital personal data different from personal data? I think personal data stored in a digital format is a digital personal data. No other sort of queries over there. Are the data captured by heat maps with as basic as the recognition of male, female, body shape, etc. is included?
It is biometric
Very,
data.
very much included.
Right. Mayank says, I run a pharmacy. In addition to my clinic, and the drug commissioner served me notice of not entering patient's address and patient's doctor's address in sales invoice. Did he serve the notice wrong? What can be my reply?
So yes, he is supposed to. I mean, there are prescription drugs which cannot be bought OTT over the counter. So yes, you need to have the address and the doctor's name there, which you need to again get a consent that you are buying these medicines. I need your prescription. Prescription should have your doctor's name, which it normally has. And yes, the drug controller has a right to ask you why the doctor's details are not mentioned in the bill. So that's very much within the legal framework.
Yeah, and I'd also like to highlight, I was reading a section in this act. I'm not able to I don't still remember the section numbers. But anyways, I was reading a section which says this act will act as a harmonious construction to other laws which are already there. So now in case of a pharmacy, the other pharmacy regulations will apply to you. In case of a banking and financial industry, the BFSI regulations, the RBI regulations will apply to you. Listed companies, heavy regulations will apply to you. So if as per suppose RBI regulations, certain KYC documents are mandatory, this DPDP Act is not coming in the way of those regulations. It will act harmoniously with them. If the sectoral regulation says you have to collect that data, so then the data fiduciary will collect that data. But as per this, they will sort of take consent, give notice, etc. So both the acts will sort of run simultaneously in collection of that data. So the sectoral regulators are not wrong in asking in case their sectoral regulations say so. Okay. Now, MJ says collection of information includes information shared through online mode or offline, submission of photocopy of PI documents. So we have covered that. I think offline, if it is converted to soft copies, it is covered. Otherwise, it is not covered. Can we store the company data also outside the country like financial data? Ratan Loda asks. While Samir said, yes, you may, I think I would sort of beg to disagree, and I'll say I have a different view. But still, I think clarity will emerge from the rules only.
DPP.
What exactly do they allow? What they do not allow? Is it a negative list or a positive list or a generic answer they give? I think better clarity will emerge from the rules only. Till now, it's anybody's guess what exactly will be allowed as a data localization or not. Okay. So are we saying physical is not covered? Yes, physical storage is not covered unless it is clarified in digital format. Okay. This question has been oft repeated, so I'm skipping the repeat questions. The physical versus digital. As per the recent amendments, Aman Agarwal asked, by MCA, we are not allowed to keep servers of our financial software outside India. So I think we have answered that question. Inside or outside India will be, again, if MCA, company law says the tally or financial softwares have to be kept in India. Now that section remains. Even if in DPDP Act, suppose they, as Samir said, they allow you to keep your servers abroad, say in US, even in DPDP Act, they allow you. But if MCA says your financial software has to be in India, then it has to be in India because this act is in addition to, not in subrogation to any other act. So
let me clarify that.
Yeah.
Nowhere it says that you cannot take the data and store it outside. It clearly says that primary copy of the data has to be always in India. It's the secondary copy we are talking about. The secondary is required because we have a concept of data disaster recovery, which means that the data is stored in data center, which is subject to, let's say, an earthquake or a flood or a power breakdown or something like that. So the DR copy can be kept anywhere in the world except negative list. Processing of data can happen anywhere, provided you have taken the consent.
Right. No, very well. And I also give you one practical example at Complinity. We are hosted on Amazon Web Servers, AWS. And earlier we were only on AWS Mumbai data centers. And as a DR measure, they opened AWS opened a Hyderabad data center very recently, I think December 22, and we were one of the first organizations to have our DR site at AWS Hyderabad. So now we have BCP DRP very well functioning with full data encryption, etc. Because we are also SOC 2 certified, ISO 27001 certified, and we feel it's not a compliance business; it's a data business that we are in, and data privacy, data protection has to be at the heart of everything that any company does.
Let me tell you in one line: the DR activity normally is not location dependent. So your primary data, let's say AWS Mumbai, DR means they can actually keep your copy anywhere in the world and provide it to you at your ask. It's a live data image of the copy.
Right. Surely. Okay, Neeraj asks, how will the government regulated all those companies who are processing data outside? How will government regulate companies who are processing data outside? I think if the government comes to know something that is not allowed, you can receive show cause notices and stuff. How will personal data such as director email address that is present in the public domain be treated? So I think email address, mobile numbers are, as Samir also said, they are the most public numbers or public things. It remains to be seen if, despite those TRAI regulations, pesky calls and pesky messages have not stopped fully, right? So similar is the concept of email. If the spamming is not allowed and if somebody does it, if the grievances are sort of put, authorities answer, people can be booked. The law is, Stephen asked, the law is applicable for the data already collected. Do we need to take the consent? Yes, I think Dr. Limaye said, even for existing data prior to the commencement of the Act, there are very clear sections in the Act saying you still need to take consent for data collected prior to the Act. Right, Mr. Limaye? Dr. Limaye?
Yes.
Yeah. Buddhaditya, asked, will the DMAT ID shares held, etc. of investors and shareholders fall under the data protection? Yes, I think so. We have been talking about employee, customers, vendors. He's asking shareholders. Will that also be data? Yes, of course, it should be data, right? As long as it's an individual, it's a data.
It's a financial data, which is my personal data. It is covered.
Yeah, because the law says any individual data, any data pertaining to an individual is a personal data, and that is covered. Now that
financial transactions are clearly defined as personal data.
Right. Okay, Chetan says, what is the process of processing personal data further? For example, I've taken a passport of foreign national to apply digital signature and sent to another vendor. So again, the vendor is a data processor or a data fiduciary, depending on his role, and he needs to take care of the data security measures. What data is.
But if he is not an Indian citizen, this law doesn't apply. If he's a European citizen, GDPR will apply. He says passport of a foreign.
If somebody is a European citizen, but he's taking a digital signature from India for some maybe MCA return. He may be a director in a company, something like that. So, in consent of the data principle, do we need to make the consent language a regional language? Yes, if your data principles are regional, you need to cover that in regional language also. Official email IDs will be covered as personal identifiable information. Just to recheck, Samir or Dr. Limaye, official email IDs, they'll also be PII?
Yes. Anything which is connected to me is PII.
Right. Okay. Somebody says, if such data is in public domain, is it okay to use or consent still required?
Who fetches the data? Consent is for the data fiduciary. If we are disclosing, that is, there is essential clause that if you voluntarily disclose any information about yourself, then that will be beyond purview of this particular consent. So here you have consented that particular public information to be used. So for those particular information, this is excluded. There is category of information, the information which is voluntarily disclosed by any data principal, that will not amount to this particular DPDP provision. So information voluntarily disclosed. Now you are sharing your visiting card. So you are disclosing voluntarily your information, e-card. So information voluntarily shared, that is out of the purview of this particular DPDP.
Right. But Dr. Limaye, it's a very thin area, I would say. If suppose on social media, there was an illustration also in the Act I was going through. If suppose somebody shares his or her mobile number and email ID on a Instagram or a Facebook or a LinkedIn post, and now if 100 other data fiduciaries who are scouting for a database they crawl and they pick up that email ID. Will that be means exempted because the person himself?
No, that is not exempted. See, please see. There is purpose when you are giving somebody a visiting card or you're sending a mail with your signature, with your visiting card address, everything. That's consent given to that person.
Right.
First of all, we should not share personal on Instagram or LinkedIn or anywhere. That's
Right.
point. All our websites have our official mail IDs and
Right.
sometimes numbers also. Government websites, you go to any RBI, SEBI, they need to
Display it.
list the mail IDs of their senior officers, including the office telephone number.
Right.
So that's already part of the public domain knowledge. Anybody can send a mail to the ex-official of any PSU because it's listed on the website.
Right.
Only reason is I can't start spamming them. I can't spam. If my mail ID is used for spam, for which I did not give a consent. So
Right.
like your misuse of the information is under covered. Not the right use is not covered.
Right. Okay, what is the provision for processing of hacked data, maybe even by legal agencies in any country? Samir, would you like to attempt? Sanjay is asking this.
So Sanjay, if you are an IT professional, hacked data is hacked data. It is illegal to use it. And so I don't want to get into more details about this.
Yeah. I would like to mix this with the earlier question, public data in the public domain. There is something called dark web, which Samir, of course, you deal with those things. So if the data is not provided by the data principal himself in public domain, but it is available as a public data on the dark web, that means, X companies' users or those companies' passwords or cracks or hacked data, as Sanjay said, that is absolutely illegal. And it doesn't mean that even if it's available on dark web, you can use it just because it's there on the public domain. No, because
it will be a clear case of penalty.
Yeah.
Clear case of penalty.
Those are the cases which may attract to 50 crore penalties. So just do it at your own. Yeah.
Yes.
Okay, so the outside.
I need to leave. I need to leave right now. I have some court matters. We are already running out of time.
We are running out of time. Yeah.
Please excuse me.
What we can do is there are few unanswered questions. What we can still do is we can try to make a compendium of these questions and try to email to the webinar registration. So
Sure.
Dr. Limaye and Samir, we may reach out to you for some expert guidance on this, some of the questions. And we'll try to do an FAQ document because the time is limited and the questions are still more. So just subscribe to our social media channels. My team, if you can again post the links to the social media channels of Complinity. Search us on any channel, YouTube or Facebook or Instagram or Twitter or LinkedIn or Spotify. Even the podcast of this show will be available on Spotify in some time. Subscribe, resources will be available, and we'll put up a FAQ document also very soon. We'll try to do that. And by the way, this is just the beginning on this subject also. Rules will come, many more notifications are expected to come. We will do a series. Dr. Limaye and Samir, we may tap into you in future also as more clarity emerges on the topic. But for now, thank you very much, Dr. Limaye and Samir, for sort of sparing a valuable time. And believe you me, at Complinity, we do genuinely believe at giving value. We do not want a decorated webinar with 50 dignitaries, with only a high-level talk. We really believe in masterclass concept where practitioners come, share their valuable experience, answer as many questions as they can, and so that the audience derives great value. And I think that's why we have a lot of repeat users coming back to our webinars and attending in large numbers. So thank you, both of you, and thank you to the audience. Thank you to the audience for appearing in large numbers, staying here, and thank you to my team for putting this together. So thank you, everyone.
Yes. Thanks a lot. This question from Mr. Orko Mukherjee, the last question that's showing, is very, very relevant. Ask your team to send this question to me. Orko Mukherjee, who has just asked a question 1:42 p.m. This is very relevant. It's about ChatGPT.
So maybe as the last question, Samir, 30 seconds we will hold Dr. Limaye.
No, it's a longish answer. I will answer it, but because it concerns everybody and it concerns ChatGPT, which is a hot topic to discuss. So I'll answer in in a more detailed form.
Understand. So we'll share all these things with the audience. Again, can we have a round of applause for all the speakers and the audience?
Thank you. Thank you.
Wonderful show. Thank you very much. Okay. Bye.
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 Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.